Good afternoon, students. Today is Tuesday, 25 January 2022. Today we're going to complete our discussion of the essay by Orin Kerr entitled How to Read a Legal Opinion. Now keep in mind that Orin Kerr is not a philosopher, and this essay is not a philosophical essay. The reason I'm having you read it and the reason I'm lecturing on it is to help you understand what a legal opinion is. We're going to be reading 3 different legal opinions in this course, and we're going to be committing philosophy on them, if you will. We're going to be examining the arguments made by the justices. So in order for you to understand the nature of a judicial opinion or legal opinion, I thought it would be good to start the course with this article. And it's intrinsically interesting as well. I hope you agree. Now, what have I posted on Canvas so far? Besides the reading list and the syllabus, I've posted the reading by Kerr. Here's my copy. I hope you printed your copy out and have it in front of you. I also posted my lecture notes on Kerr, which I'll be going over in just a couple of minutes, and you can follow along. I have now posted a couple of items on the next reading. I've posted Lon Fuller's famous case called The Case of the Spelunkian Explorers, and I have now posted my lecture notes on that reading. So when we meet again later this week on video, I hope you have read at least half of Fuller's article, and I hope you've printed not only the article, but my lecture notes so that you can follow along as I do my recorded lecture. I've also posted a couple of other minor items. I posted a map of United States Courts of Appeal. I showed it to you a couple of days ago when we went over Kerr for the first time. And I've posted a handout entitled Spelunkers. It shows you that Fuller's famous article on spelunking has been very fruitful. Lots of other law professors have written similar accounts or have written about Fuller's essay itself. Now I have a few more items to post on Fuller, so pay attention to Canvas, check it every day or so. Whenever you see something new, print it and have it in front of you when you watch my recorded lecture. Later in the semester, when we go back into the classroom, make sure you've printed and brought into the classroom whatever items you have found on Canvas. So try to stay on top of things. Okay, so my second lecture this week, I'm thinking will be posted on Friday. I have a number of odds and ends to do this week. One nice thing about recording my lectures is that they don't have to be done on Tuesday and Thursday, although I'll try to do it on those days. Today, for example, is Tuesday. But I think the second lecture this week will be posted sometime on Friday. So again, I'll send an email as soon as the lecture gets posted. Okay, let's get to our reading for today by Orin Kerr and finish things up. I allocated only 2 class periods to this fairly short article, and today is the second of 2. So let's turn to section 2 of Kerr's essay, which is entitled Common Legal Terms Found in Opinions. One of the things that will strike you when you read a judicial opinion or legal opinion is it will be filled with unfamiliar terms. I remember when I began law school way back in 1979, we had a number of cases to read in each of our courses, and it was very slow going because it seemed that I had to look up every other word in my dictionary. Eventually, of course, I learned what the words meant, and I didn't have to recur to the dictionary quite as often. So that's part of the learning process. So what are some of these terms that you see in legal opinions? Well, Kerr lists a few of the main ones. The word plaintiff, the word defendant, some people pronounce it defendant, and it helps them remember how to spell it. It's Defendant, not ENT. And so some people mispronounce it defendant, just so they remember how to spell it. Other words that you sometimes see, all of which come from the French language, are the words tort, contract, crime, and judge. Believe it or not, all of those English words derive from French words long ago. So you could say that our legal vocabulary is French in large part in its origins. Other words in the law come from Latin. Latin is an even older language than French. In fact, French is called a Romance language, like Italian and Spanish, because French, the language, derives from Latin. So the law is filled with words from Latin, French, English, and even other languages. Some German words appear in legal opinions, or Spanish or Italian, but lots of them from French. Now, a law student in particular, needs a good law dictionary to make your way through the readings. I can tell you that my law dictionary, which I purchased when I started law school in 1979, was the 5th edition of Black's Law Dictionary. Black's Law Dictionary. It's one of the more prominent law dictionaries. Not the only one, but it's quite famous. And I just checked a few minutes ago. The most recent edition of Black's Law Dictionary is the 11th, and it was published in 2019, just 3 years ago. So between the time I started law school in 1979 and today, there have been 6 additional editions of the dictionary. Okay, let's talk a little bit about different types of legal dispute. As you know, there are criminal disputes and civil. That's one of the main distinctions in the law, a civil case versus a criminal case. And the language differs depending on what sort of case it is. In a civil case, one person sues another. One person brings a lawsuit against someone else. And the typical thing you ask for in a civil suit is damages. Somebody you claim has wronged you in some way and caused you harm or injury, and your goal is to be made whole again. So you will sue for damages. You will try to recover a sum of money in the case. The other side, the defendant, will of course try to show that he or she did not wrong you, and will ask that he or she not be made to pay a sum of money to you. Sometimes in a civil case, what the party who sues wants is an injunction. Suppose somebody is trespassing on my property. I certainly will want the person to be ordered to stop trespassing. So, among other things, I will ask the court, when I go to court, to issue an injunction against the trespasser. And if that person violates the legal injunction, then he or she can be in serious trouble. In fact, you could theoretically be jailed if you persist in violating an injunction, because now you're violating a court order, and that's serious business. So in a civil case, you typically ask for an injunction or monetary damages, or both. In a criminal case, as you know, there is a prosecutor, sometimes called the state, the prosecution, or sometimes the government. Some agent of the state or agent of the government files charges against you or files an indictment against you. You are the defendant. You have, according to the prosecutor, violated one of the criminal laws of the jurisdiction. And the prosecutor in a criminal case is not asking for an injunction or monetary damages. The prosecutor will be trying to get a conviction and ultimately punishment. The prosecutor will be asking the judge to punish you. And of course, the punishment could take the form of a payment of a fine to the government, It could take the form of restitution for your victim, where you pay the victim of your crime a sum of money. It could involve confinement in a prison, which means you've lost your liberty for a period of time. And it could even be loss of life. It could be a sentence of capital punishment, where you are put to death by the state. Not every state allows capital punishment. Texas, our state, does, and people are from time to time put to death in accordance with the law. There are different standards of proof in civil and criminal cases, as you probably know. The standard of proof is weaker in a civil case. Typically, if you sue somebody, you have to prove by a preponderance of the evidence that the other person wronged you and is liable to pay damages to you. In a criminal case, the standard is significantly higher. It's called proof beyond a reasonable doubt. The idea is that the jury, if the jury has even one reasonable doubt about any element of the criminal offense with which you're charged, the jury is supposed to acquit you, which means find you not guilty. And you've probably heard the slogan, better that 10 guilty people be freed than that one innocent person be convicted and punished. It's an old slogan, and it suggests that we value one sort of error worse than another sort of error. There are two errors that could occur, after all, in a criminal case. We could convict the innocent, or we could acquit the guilty. And what that slogan suggests is that one of those two errors is much worse than the other one. It's worse to convict and punish someone who's innocent than it is to let go or acquit someone who is actually guilty. Okay, so the standards of proof differ. And by the way, I could ask you a question on the exam about any of these matters. Now, again, this is not a philosophical essay, but I can test your reading comprehension and your whether you have put in the time by doing the reading carefully and by listening to my or watching my lectures attentively. So I could ask you a question about any of these things I'm talking about right now. So make sure you understand all of these distinctions and concepts. In American law, the terms attorney and counsel or counselor are used. A different set of terms is often used in England. There they call their lawyers solicitors or barristers. So the names differ depending on the country or jurisdiction. The judge is called by a formal name, at least in our system. We and by that I mean the attorneys in court, refer to the judge as Your Honor or the court. An attorney may say in court, for example, may it please the court, I would like to call my first witness. So a lot of formality occurs in courtrooms. It gives the law an aura of respect that may or may not be deserved. But judges dress in robes. In the old days, they wore powdered wigs. They have gavels. Typically, in a courtroom, the judge is sitting at a level above everyone else, behind a desk, and so on. Often there are flags in the courtroom or plaques on the wall, slogans may be written in the courtroom, that sort of thing. So the whole idea of a courtroom is that it's a place of respect and that everyone should have respect for the law, for the rule of law. It's a way to resolve disputes in a peaceful way, an orderly way, rather than violent or chaotic. Now let's take a look at some of the terms that are used in appellate litigation. At the trial stage, whether it's a civil or a criminal case, the judge will issue rulings on motions and so on. Eventually there will be a verdict by the jury or by the judge. Sometimes there is no jury and the judge will issue the verdict. Now, if you are on the losing side in a trial, whether it's a criminal or a civil case, you typically have the right to appeal. And what you appeal are not factual matters, because those lie within the province of the fact finder, the jury, for example. What you would appeal are matters of law. If you believe that the trial judge, made a mistake of law in a ruling on a motion, for example, then you can issue a protest at the time the ruling is made, and that way you're preserving that issue for appeal. And at the end of the trial, you can file an appeal with a higher court, and you could ask that court to reverse the ruling of the trial court. And that may mean a new trial. You may be able to get a new trial from scratch because the trial judge made an error of law. Now, not all errors of law are appealable or are likely to be successful. Some errors are said to be harmless. So imagine this. Suppose the trial judge makes an error, a legal error during the trial. You appeal because the error worked against you. The appellate court may agree with you that an error was made by the trial court, but disagree with you that the error was harmful. The appellate court may say that it was a harmless error. And what that means is that the error would not have made a difference in the outcome of the trial. It was harmless. Other errors are harmful. They do make a difference to the outcome, or might well have made a difference to the outcome. And so the appellate court may well rule in your favor and say, we reverse the lower court ruling and we send the case back to the trial court for further proceedings, including perhaps a new trial. So the term that is used is reversal. The appellate court will either reverse the lower court or affirm it. Affirm means let it stand. Okay? And sometimes there may be another appellate court above the first appellate court. The U.S. Supreme Court is the second level appellate court. So if you appeal your trial verdict to the United States Court of Appeals, say the Sixth Circuit may affirm the trial court, which means you lost again. You can then ask the U.S. Supreme Court to take the case. Now, the U.S. Supreme Court can take only a very small percentage of cases each year. After all, it's a 9-justice court, and there are so many cases appealed each year that the court can take only a small number of them. So all you can do is ask. Your request or petition may be denied, or it may be accepted. And of course, if it's accepted, you could lose again. So you could lose at all three levels. You could lose at the trial court level, which is called the district court. You could lose at the first appellate level, which is called the circuit court. And you could lose for a third time at the U.S. Supreme Court. The same sort of thing can occur at the state level as you move through the state system of courts. Now, in the U.S. Supreme Court and on most state Supreme Courts, the judges are called justices. And at other levels, they're called judges. So in the federal system, if it's a trial court, the district court, it's called a judge. If you appeal to the circuit court, that's also called a judge. Usually there's a 3-judge panel who will hear your appeal. And if you reach the U.S. Supreme Court, the judges have the name justices. There is, as you know, a Chief Justice of the U.S. Supreme Court. The other justices are known as associate justices. So you have 1 Chief Justice and then 8 associate justices. It's similar to academia. In an academic department, you may have certain professors who are full professors or just plain professors. Others are called associate professors. Typically, they have tenure. And then there are assistant professors who are typically not yet tenured, people who hope to become tenured one day. So We have just different names for different categories or different roles. Now, keep in mind something interesting. I didn't quite realize this when I was in law school. It was only later that someone mentioned this. I wish I had known when I was in law school. The cases that you read in law school, in the big, thick case books, some of them are this thick, several inches thick, the cases that you read are usually cases that have been appealed from the trial. Now, if the case were an easy case, legally speaking, the chances of it being appealed would be very small. So turn it around. If you are reading a case that was appealed, it probably raised a novel question of law. It was probably a hard case. Hard, by hard I mean difficult, right? Otherwise it would not have been appealed. Easy cases tend not to be appealed. They're resolved at the trial and they stop there. It's only the hard cases that end up getting appealed. And a hard case in the law means a difficult case, a case where there's no law that applies to the facts of the case. Or it may be that there is law that applies, but there may be a conflict. One precedent may point in one direction, and another precedent may point in the other direction. And so it would take an appellate court to decide which of the two precedents takes precedence, so to speak. No pun intended. So keep in mind that when you read an appellate opinion, and all of the cases that we'll be reading in this class are appellate cases, that they're likely to raise novel and difficult legal issues. And if they didn't, they wouldn't have gotten that far. They would not have been appealed in the first place. So that means that when you're in law school reading cases, you just get a succession of difficult cases where the legal issues are quite difficult. Okay, let's turn to section 3. Now I'm going to get my copy of Kerr. I'm going to show you where section 3 begins. It's on page 57. Here it is. You can see in yellow I have highlighted section 3. The title of section 3 is What You Need to Learn from Reading a Case. Now this is good advice for law students, but also for you, since you are going to be reading some actual legal opinions in this course. Now on page 57, Kerr writes the following. He says, here is what professors, and he's talking about law professors, here is what professors want students to know after reading a case assigned for class. And he goes through and breaks it down. Let me give you the breakdown. First of all, you need to know the facts. Secondly, you need to know the legal arguments, the specific legal arguments made by the parties to the case. Third, you need to know the disposition of the case, in other words, who won and who lost. Fourth, you need to know the reasoning of the majority opinion. What's the reasoning? It's not enough just to know who won. What you need to know is, why did that person win? What were the reasons? What was the reasoning? Next, you need to know the significance of the majority opinion. And finally, you need to understand any concurring or dissenting opinions there may be, because sometimes they shed light on the issues. They shed light on the scope of the ruling, which is important going forward for future courts. And sometimes they show weaknesses in the majority reasoning. Okay, so dissenting and concurring opinions are very important. You should never ignore them. So let's go back to the facts, the first element of what you need to know. Kerr is a strong believer in the importance of the facts and of knowing the facts. Here's what he says. If you don't know the facts, you can't really understand the case and can't understand the law. If you can't understand the case, then of course you can't understand the law that the case makes or applies. So let me read footnote 2 aloud from page 57. It bleeds over onto page 58. Kerr, in the text, has said, "Trust me, the facts are really important." And here's his footnote. If you don't believe me, you should take a look at a few law school exams. It turns out that the most common form of law school exam question presents a long description of a very particular set of facts. It then asks the student to, quote unquote, spot and analyze the legal issues presented by those facts. These exam questions are known as issue spotters, as they test the student's ability to understand the facts and spot the legal issues they raise. As you might imagine, doing well on an issue spotter requires developing a careful and nuanced understanding of the importance of the facts. The best way to prepare for that is to read the fact sections of your cases very carefully. And you'll see later this week when we get started on the hypothetical case of the spelunkers, you'll see that there's a long discussion of the facts. And I want to make sure before we go on to the reasoning of the justices that you understand all of the facts, because the understanding the facts will help you understand the issues that are raised by the case and ultimately how and why the justices resolved the issues. Okay, so pay attention to the facts. I remember in law school many years ago, it was in my torts class, and the question went on and on it was just filled with all kinds of facts. And as you read the statement of facts, you didn't know which of those facts would turn out to be legally relevant and which would not. It went something like this. A young man, let's say a 17-year-old high school student, got a part-time job at a local golf course. His job called for him to perform certain tasks. For example, he was to make sure that there were enough golf balls available at the driving range, and lots of other things too. He was a kind of a jack of all trades at the golf course. Now one day, a friend of his came to visit him while he was at work on the golf course. He got a hold of a golf cart and took his friend for a ride in the golf cart on the golf course. And a series of things happened as they went along. They were goofing around. And eventually something terrible happened. The golf cart tipped over into one of the ponds, and maybe the friend drowned. And it went on like this for a long time. At the end of it, the law professor said, in effect, spot the legal issues and analyze them. So you had to go back to the beginning, and with the eye of a trained attorney who understood the law, you had to spot the issues. You would say, for example, that the employee's taking of the cart was an act of negligence by the employer, arguably an act of negligence. The employer should have seen to it that the keys were not in the carts, for example, so that the workers couldn't drive them without permission. And then eventually there would be a legal issue about who's responsible for the drowning. And so you would end up writing maybe over an hour, even 2 hours, answering that one question. Okay? It was an issue spotter, just like Kerr described in his footnote a moment ago. Okay, let's turn to the next section. You should make sure that when you read a legal opinion, you understand the specific legal arguments made by the parties. Now, this may surprise you, but when two people go into court in a civil case, the judge is supposed to be inert. The party filing the lawsuit claims that a wrong was done and that the other person, the defendant, is responsible for that wrong and should be ordered by the court to pay damages. Now, the court will allow the parties to frame the issues in a civil case. And if it's appealed, the appellate court will allow the parties to submit briefs. Excuse me. Each party will frame the issues in such a way that it will help his or her case. The judges do not decide what the issues are. The parties do. That gets worked out in the briefs. So once the plaintiff on appeal, the appellant, is what the appellant or petitioner is what the losing party is called when he or she appeals to the appellate court. The appellant or petitioner will make certain legal arguments. The brief will then be delivered to the defendant, or what's usually called the appellee or respondent. So the terms on appeal are appellant, appellee. The appellant is the one who brings the appeal. The appellee is the one who responds to the appeal. Sometimes the words petitioner and respondent are used instead, and it just depends on which court you're in, state or federal, and if it's state, which state. Okay, so my point is that on appeal, the party who won at the trial level will respond to the brief filed by the appellant. And if the appellant makes a certain argument, then the appellee will respond to that specific argument. The judge plays no role in framing the issues. The parties do that in their briefs. Now, here's what Kerr says about that on page 58. Because the lawyers take the lead role in framing the issues, you, the student, the law student, need to understand exactly what arguments the two sides were making. So you would read the briefs by both parties, and you would read them carefully to make sure you understand what argument is being made by the appellant and what argument is being made in response to that by the appellee. Okay? Sometimes the court itself will summarize the facts. And you're going to see examples of that in this course. And if you don't have access to the briefs that were submitted by the parties, and you will not in this course, you're going to have to rely on the facts as they're stated by the appellate judges. And that's all you'll have to go by. But you'll have to read them very slowly and very carefully, making sure you understand what happened and why. One term I want to mention before we go on. Remember earlier the other day when we got started on Kerr, we discussed the term per curiam. You remember what that means? Per curiam. Excuse me. It means by the court. It's typically a short opinion issued by the whole court on appeal without any names being listed, any names of the justices. It's a ruling issued by the whole court. Now I want to introduce a term, amicus curiae, or amicus. Some people pronounce it amicus. Amicus curiae. And it means friend of the court. Amicus is friend. It's related to the Spanish word amigo, for example. It probably comes from the Latin word. I'm sure it does. And curiae is similar to curiam in the phrase per curiam. So an amicus curiae brief is a friend of the court brief. Now let me back up and explain a little bit. Suppose I have sued you in a trial court and I lose. I lost at the trial court level. I believe an error was made, a legal error, at the trial, and so I'm going to appeal to the lowest level appellate court. There are groups in society who might have an interest in that case, in my case, because of its long-term significance for society. So these groups or even individuals will petition the appellate court for permission to file a brief. Either on the same side as I am or on your side. Right? So you get amicus briefs filed by different third parties on each side of the case. Okay? So that's a very common practice. You do have to get permission from the appellate court to file the brief. Once the brief is filed with the appellate court, it will typically be read by the parties, maybe by the clerks of the court, maybe by the justices or judges themselves. So the point of the brief is to bring additional arguments to bear, to help the court make a ruling, a better ruling, a more informed ruling, a better reasoned ruling. So often there are lots of briefs filed in a particular case. Not only the briefs by the parties to the case, but by all these amici who are interested parties. Okay, so I could easily test you on that. Make sure you understand the meaning of terms like per curiam and amicus curiae or amicus curiae. Let's talk now a little bit about the disposition of the case. The disposition is simply the action the court took. Those are Kerr's words on page 58. So what did the court do? You're reading a case, make sure you pay attention to what ended up happening. What did the court decide? The court may have affirmed the lower court ruling, or it may have reversed it. Excuse me. Other terms you sometimes see are vacating. The appellate court may vacate the lower court ruling, which means empty it. It means deprive it of any effect. So if I'm the appellate court, I may vacate the lower court ruling and remand the case to the original court, the trial court. Remand means hand back. Mand means hand. Re means back. So vacate and remand means empty the case of any legal force and hand it back. Often there are instructions. The appellate court will hand the case back with instructions to perform a new trial, or sometimes it's general, to take whatever steps the trial court deems necessary. Okay, leaving it up to the trial court exactly what to do. Now, there's an important distinction that I want you to know and may test you on. Don't confuse reversing a case with overruling a case. When an appellate court reverses a case, it's reversing the court below it. So think of a hierarchy. A hierarchy goes up and down. You've got the Supreme Court at the top, and then the lower level appellate court, and then down below it, you've got the trial court. See the hierarchy? Suppose you're at the Supreme Court level. The Supreme Court may decide to reverse the intermediate appellate court. Okay? The Supreme Court disagreed with the ruling and is going to send the case back to the appellate court with instructions to do the case again, or redo the case, or do something else, to give the winning party some other kind of relief. Overruling is very different. Sometimes the Supreme Court overrules itself. When you overrule, you're overruling your own court from a previous case. So it's not up or down, it's not vertical, it's horizontal. Overruling is horizontal, reversing is vertical. So here are some examples. Sorry, a little cough. In 1986, in the United States Supreme Court, a case called Bowers versus Hardwick, the court overruled, let me back up. It was 2003 in a case called Lawrence versus Texas. The U.S. Supreme Court overruled, in that case, its own previous precedent called Bowers versus Hardwick, 1986. So in just 17 years, the U.S. Supreme Court overruled itself. It came out and explicitly said, we hereby overrule our previous case, Bowers. Excuse me. Another famous example, in 1954, the U.S. Supreme Court, in the case of Brown versus Board of Education, overruled a case from 1896 called Plessy versus Ferguson. So that 58 years elapsed between the original case and the overruling. Some people think that Roe versus Wade, the 1973 abortion case, may be overruled by the current court. There is a case currently pending before the court out of Mississippi, and the court could very well later this summer overrule Roe v. Wade, either explicitly or implicitly. So lots of people are watching with bated breath to see what the court does. Now, 1973 is how long ago? Almost 50 years. So Roe v. Wade is a very old precedent, but not so old that it can't be overruled. We saw in Brown v. Board of Education that it overruled a case that was decided 58 years earlier. So the mere fact that a case was decided several decades ago doesn't mean that the court will refrain from overruling it. Right? We see that in the case of Brown. Okay, let's move on to the next subsection. What about the reasoning of the majority opinion? When you read a legal opinion, make sure you pay attention carefully to the reasoning of the justices, whether it's the majority opinion, a concurring opinion, or a dissenting opinion. They're all reasoned. The justices engage in reasoning. They state reasons in support of their decision or ruling. And you need to know exactly what the reasoning is. Kerr points out that there are various sources of law that might be used by these justices. The justice may apply a constitutional provision, a part of the Constitution, either at the federal level or a state level. It could be that the judge uses a statute enacted into law by the legislature and signed into law by the executive. It could be that the case is decided on the basis of a previous judicial ruling, which is considered a precedent. And sometimes that's called common law at the state level. The common law is judge-made law. And often that judge-made law goes back many, many decades or even centuries. Now, there is a hierarchy of law, and here's how Kerr puts it on page 59. Constitutional rules trump statutory or statute-based rules, and statutory rules trump common law rules. So the hierarchy is the Constitution is the supreme law of the land. Below the Constitution, you get statutes, which are enacted bills. And below that are judicial cases, previously decided judicial rulings. Now, don't think for a moment that these previously decided cases are unimportant. They're very important. Many, many cases are decided based on precedents. All Kerr is saying is that whenever there's a conflict between a constitution and a statute, the Constitution prevails. And whenever there's a conflict between a statute and a court opinion or a court ruling, the statute prevails. So there's a clear hierarchy of law in the United States, both at the federal level and within each state. Now, you may have heard of the doctrine of stare decisis. You can see it there in my notes on page 5. Stare decisis is, those, by the way, are Latin terms. Stare decisis is the doctrine that says, let previously decided cases stand, right? If there's been a case in your jurisdiction previously decided and it's relevant to your case, the court should follow precedent. There's a presumption that previously decided cases will be followed. Now, it's only a presumption because, as you just saw a moment ago, sometimes the court will overrule its previously decided cases. And in that case, the presumption is said to be rebutted. So a presumption just means this is the way things will stand unless and until there's good reason to overrule them. Okay? You can even say it's a strong presumption that previously decided cases will be allowed to stand rather than being overruled. Okay? Now, sometimes when judges decide cases, they base their rulings on public policy. Now, this is controversial. Judges who base their rulings on public policy are often criticized for it on the ground that this is law being made and not public policy. Public policy, so the argument goes, is for the legislature of the state. Public policy is to be made by elected officials, including the executive, who signs the bills into law. Judges, according to this way of looking at things, judges are not policy makers. Their job is to apply the law as they find it, not to make the law. So there's a lot of controversy swirling around public policy. Should judges ever make policy? Yes or no? That's a controversial matter in the law. Some say no, some say yes. When we get to the Spelunker case, you'll see that one of the justices, Justice Handy, believes in using public policy. In fact, Justice Handy's view is that literally anything may be used by the judge or justice when deciding a case. Anything. Public opinion polls, the judge's sense of right and wrong, public policy, economic considerations, cost-benefit analysis, whatever. Right? Justice Handy has a wide open view of what sorts of things the judge may bring to bear in deciding a case. But let's hold off on that until probably the third of 3 days on the Spelunker case. Now, sometimes morality itself is brought to bear by judges. There's a famous case out of New York in 1889. It's called Riggs versus Palmer. Just to give you a short version of it, a young man who was named in the will of his grandfather murdered his grandfather because he thought that the grandfather was going to take him out of the will. So he thought if he murdered him before he changed the will, he would be able to inherit money. Now, perhaps he thought he would get away with the murder, but he didn't. He was convicted of murder and confined to prison. And this case involved whether he was entitled to take under the will. Now, when the judges on appeal in the state of New York looked at the law, they found no basis for disinheriting him. He was named as a beneficiary under the will. The will was valid under the laws of New York at the time the grandfather died, and therefore, you would think the grandson is entitled to inherit the money. And it was a large sum of money. Well, guess what? The court in New York, the highest court in the state of New York, disagreed with the young man and said he does not get to inherit the money. And here's what the court said to justify its reasoning, its decision. I'm quoting from my page 5 of my lecture notes. No one shall be permitted to profit by his own fraud, or to take advantage of his own wrong, or to found any claim upon his own iniquity, or to acquire property by his own crime. These maxims are dictated by public policy, have their foundation in universal law administered in all civilized countries, and have nowhere been superseded by statutes. And based upon that, the court ruled that the young man, the murderer, was not allowed to inherit the money. So the grandfather's money was given to either other relatives or to the state, but not to the young man who murdered him. Now, that case is quite famous. It seemingly shows that judges will not apply the law when they think that the result of doing so will be unjust or unfair or simply immoral, wrong, or against public policy. So this is often said to show that appellate courts can, and sometimes do, and perhaps even should, bring morality or moral principles to bear in deciding cases. Again, there's controversy about that. Some people say it's not the job of a justice to apply moral principles in a legal case. Law is one thing, morality is another. Others say that it's sometimes permissible for a judge to apply moral principles in order to ensure that an injustice isn't done. And they cite this case as an example. Do you agree that there would be a grave injustice if the young man who murdered his grandfather were allowed to get rich as a result of his heinous act? The judges, I think, didn't want to be a party to that. The judges said, look, it would be nice if there were a provision of New York law that allowed us to deprive this young man of his inheritance. But we can't find any such provision. But we're not going to let him take the money. We're going to find a way to take the money away from him. And they did, by applying moral principles. Okay, let's move on. What's the significance of the majority opinion? Now, I made a distinction earlier in our discussion of Kerr's essay between the holding of the case and the rationale, between the decision itself and the rationale for the decision. The decision you can think of as the holding, and the rationale you can think of as the reasons to support it. Now, sometimes judges throw in words, dicta it's called, which is Latin for words. Sometimes judges say things in their opinions that do not have the force of law. They're gratuitous. In other words, the judge didn't have to say that in order to support the ruling or the holding. So every law student has to learn which parts of the opinion are part of the actual holding of the case and therefore have legal significance in future cases, and which parts of the case are mere words. Dicta. Obiter dicta is what it's called. Now let me give an example of this. Very interesting. In 2003, maybe around the time some of you were born, but it seems like yesterday to me, in 2003, in a famous Supreme Court case involving affirmative action in higher education, Justice Sandra Day O'Connor of the U.S. Supreme Court made a claim in her opinion. And here's what she said. Now, it's in my lecture notes somewhere. I have to take a moment to find it. I was pretty sure I had it in here. Maybe, hold on a moment. It may be that it's in my other lecture notes on the Spelunker case. Yes. See, my memory may not be as good as it once was, but it's not completely bad. Okay, this is from page 9 of my lecture notes on Lon Fuller's essay on the Spelunkers. This is Sandra Day O'Connor in 2003 in a case where she voted to uphold affirmative action programs in higher education. Listen to what she said. She said, "It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time, the number of minority applicants with high grades and test scores has indeed increased. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Now think about that. Justice O'Connor voted to uphold affirmative action programs in higher education, at least in public universities. But then she said, actually she used the word we, so she's presumably speaking for other justices on the court at the time. She's saying, "We think that in 25 years, there will no longer be a need in society for racial preferences or affirmative action programs." Now, here's the question. Was that statement essential to her ruling in the case? The answer is no, it wasn't. She just threw that in. That's dicta. That's gratuitous language. You could say that's just her opinion, not her legal opinion, which is binding because she's a justice, but her personal opinion. Okay? Now, we're almost to the point where 25 years have elapsed. 2003 is when she wrote that. Add 25 years and you get 2028. It's now 2022. So 6 years from now, we will have reached the point at which Justice O'Connor thought we will no longer need affirmative action programs in this country, at least for race. It'll be interesting to see what happens, won't it? In 6 years, will the court look back and say, Justice O'Connor said affirmative action has only 25 more years to go. 25 years have elapsed. No more affirmative action? I doubt it. I think it's far more likely that justices 6 years from now will say, oh, that was just Justice O'Connor throwing in her 2 cents worth. What she said there was her own personal opinion. It was mere words. It was obiter dicta. And it has no legal significance. And it does not bind us here now in 2028. So let's go back to the point. The point is, when you're reading a case, you need to be able to determine which language is part of the holding of the case, which language has legal significance going forward, and you need to be able to distinguish that from these comments thrown in as dicta, which have no legal significance, which don't bind anybody in the future. So I've just given you an example of dicta by Justice O'Connor. She's no longer on the court, although I believe she's still alive. I wonder what she now thinks about affirmative action now that 19 years have elapsed since she wrote those words. Now, some opinions are very well reasoned, others not so much. In the cases we'll be reading, you'll see differences in the quality. Some justices on the U.S. Supreme Court are known as careful thinkers and careful reasoners. Others are prone to sloppiness. And I'm not going to name any names. Different people have different opinions about which justices are sharper or the sharpest and which are not so sharp, intellectually speaking. And don't confuse reasoning with writing, right? There are people who are brilliant writers, but maybe their reasoning skills aren't all that well developed. But they're very good at articulating their ideas. They're good writers. Writing is a skill. Some people are good at it, some are not so good. Right? Reasoning is a skill. Some people are better than others at reasoning. So don't commit the simple mistake of thinking that because a particular justice is a good writer, that his or her reasoning is therefore likely to be good or better than someone else's. Okay? You can have good writers who are poor reasoners, and you can have bad writers who are good reasoners. You can also have someone who's good at both or bad at both. So there are 4 possibilities, aren't there? Let me just mention a couple of very stylish writers. And by claiming that they're good writers, I'm not at all implying that they're not good reasoners. Richard Posner, who retired a couple of years ago from the 7th Circuit Court of Appeals in Chicago, Richard Posner was a prolific writer. He not only wrote all of his own legal opinions over a period of several decades, his clerks didn't write them, he wrote them. That's very unusual. Most appellate judges assign to their clerks the task of writing legal opinions. Posner wrote his own legal opinions, all of them, thousands of them. In addition, he was a productive scholar. He had been a law professor before he was put on the bench on the court. And he continued writing books and articles all the time he was on the Court of Appeals. What an amazing person he is. I've read many of his books and articles. They're all not only beautifully crafted, beautifully written, but he's quite a smart man. In fact, when he was a law clerk for William Brennan many years ago, shortly after he got out of law school, Justice Brennan said that in his whole life he had known only 2 geniuses. One of them was his Supreme Court colleague, William O. Douglas, and the other was his former clerk, Richard Posner. Now that's pretty high praise when a Supreme Court justice says, you are one of 2 geniuses he has ever known. So Posner was a brilliant judge, a prolific author, and a great writer. I recommend that you track down a book or an article written by Posner and see for yourself. I've often said that if I were stranded on a deserted island and I could pick the works of only one author to have with me on the island for the rest of my life, I would pick Richard Posner. The only rival would be the philosopher Richard M. Hare, H-A-R-E. He wrote a lot, he's interesting, I learned a lot from him, and he was a good writer as well. So if I were on an island, I'd pick either the works of Hare or Posner. I'd love to have both, but if I had only one, I'd have to flip a coin or something. All right, one more example. Antonin Scalia, who was on the court for several decades, the Supreme Court, and who died several years ago and was replaced. And he died in 2016, 6 years ago. Scalia was a provocative and interesting writer. Even his critics admit that. If you read an opinion by Antonin Scalia, you will be riveted. It will be riveting. He was a very provocative writer. He had a way of luring you in. He was stylish. And again, I'm not implying that his reasoning skills were less than superb. Right? He may have been one of those rare individuals who was brilliant at reasoning and at writing as well. Okay, almost done for the day. Always pay attention to concurring and dissenting opinions. As Kerr puts it on page 61, these are, quote, very important. He says, disagreement between the majority opinion and concurring or dissenting opinions often frames the key issue raised by the case. And you'll see when we get to the 2 actual cases in this course, Atkins versus Virginia, and before that, Cohen versus California, there are dissenting opinions and in some cases concurring opinions, and you'll see just how they differ from the majority opinion. Okay, final question. Part 4 of Kerr's essay, Why Do Law Professors Use the Case Method? In law school, in a torts class or contracts or property, the law professor rarely, if ever, lectures the way your undergraduate professors do, the way I do. Instead, law professors typically have a question and answer approach. It's called the Socratic method. The law professor will call on a student in the class. Sometimes the student will stand up for the whole period. The law professor will ask that student a series of questions about the case or cases that were read for class that day. And the professor will never say to the student, your answer is correct or incorrect. What the professor will do is ask a question, let the student answer it, and then ask a follow-up question. Once the student answers it, the professor will ask another one. It's a back and forth, question, answer, question, answer. And it takes some getting used to, let me tell you. If you come out of college into law school and you find the professor is never providing any information to you, but only asking questions, it's very disconcerting. The professor's purpose in asking questions and allowing you to answer them is to get you to think through the issues in the case for yourself. For example, what if the plaintiff, well, go back to my example about the golf course. Suppose the young man who drove the golf cart, the employee of the golf course, was 17. The professor will ask a series of questions about the liability of that young man or of the golf course, the owner of the golf course. At the end of that question and answer session, the professor may say, suppose the young man was 18 rather than 17. Does that make a difference? And if so, why? The student would then take a moment, think about it, and then answer the question. The professor might then say, what if the student were 21? Would that make a difference legally or not? And if so, why or why not? So in law school, the procedure is to go back and forth between the student and the professor. And the idea is that the issues will become sharpened and that the principles involved in the case will emerge. They will come out of the discussion, so to speak. And the other students in the class will be busy trying to extract the relevant principles from the discussion. And of course, they're going to be nervous because they may be the next one called on, either that same day or the following day. So it's a very tense atmosphere. I recall being petrified in some of my law school classes. And yes, I was called upon from time to time. Sometimes I did well, sometimes not so well. I have vivid memories of those times when I may have been unprepared or inadequately prepared. And maybe I couldn't answer the questions posed by the professor. So let me tell you, it certainly served as a motivation to do your reading, to read it carefully, to make good notes, to brief the cases, right? What better way to motivate yourself to be prepared than the prospect of humiliation in front of your peers? No one wants that. Okay, so, well, I'm going to give you an anecdote that that may scare you if you plan to go to law school, or maybe not. At some point in our first year of law school, I think it may have been in the second semester. So we've been in class for months. And you're in the class with the same group of students. There were about 75 of us. And we took all the same classes together, torts, contracts, property, and so on. And we got to know each other pretty well. Late in the class, one of the students stood up, and started screaming at the professor. He said the professor had been humiliating us all semester. He was sick of it. He wasn't going to take it anymore. And he stormed out of the classroom. And guess what? He never came back. He quit law school, having spent several months. It got too much for him. The pressure was unbearable for him, and he left. Very sad, because we all liked him. And even sadder, there were a couple of cases in my own law school class where students committed suicide. The pressure was so great that they cracked and ended their lives. Now that is terribly sad and tragic, but it happens. It's a very stressful environment. So why do law professors use this method, the case method? Why do they have students read actual cases and then use the Socratic method back and forth? Well, one of them is historical. Kerr says on page 62, the reason is this: to understand judge-made law, which is called common law, we need to study the actual decisions that the judges have written. That makes sense. So that's an historical reason. Right? If you want to understand the law made by judges, you've got to read what they wrote, what they did. And secondly, there are practical reasons for this approach. According to Kerr, studying actual cases in these thick case books, quote, teaches an essential skill for practicing lawyers, unquote. After all, law school is a training ground. The law professor's job ultimately is to prepare these students for the practice of law. So according to Kerr, the skill that the professors are trying to inculcate in their students is to understand, quote, exactly how an abstract rule of law will apply to the very specific situations a client might encounter, unquote. So think about it. You've gotten through law school, you've passed the bar exam, you're licensed to practice, you open up an office or join a firm. A client comes in to see you one day, wanting legal representation. You will introduce yourself, ask the client to sit down, the potential client, sit down. What's on your mind? Why are you here? The client will probably in a rambling way describe what happened. The client obviously thinks that he or she has a good legal case and will tell the attorney all kinds of things, much of it may be irrelevant. The attorney, having been trained to notice details, the attorney will listen carefully, maybe ask a few follow-up questions, and then tell the client, probably in that first meeting, I don't think you have a case. We're going to lose. You're just going to waste your money, and you're going to be disappointed. On the other hand, the attorney, having listened to the case and asked some follow-up questions, the attorney might say, I think we may have a case. It's worth going forward. It will cost you a certain sum of money, but there's a chance that you'll recover damages and it'll be worth your while. So I would recommend going forward with the case. So that may be the result. But the point is, the attorney, highly trained in knowing what the law is and listening carefully to the facts provided by the prospective client, the attorney will make a judgment about your likelihood of prevailing on the merits of the case. So that's why law professors are so hard on students. Well, for one thing, judges are going to be hard on attorneys, are hard on attorneys in the courtroom. So you've got to grow up at some point. Maybe in college you were a wallflower. I was. Can you believe it? Now that I'm a professor, it's hard to believe that at one point I was one of those quiet students who sat in the back and listened carefully and made good notes. I did well, but I wasn't one of the more talkative students in any of my classes. Law school was hard. It made me come out of my shell psychologically and personally. And when the law professors made me stand up and put me on the spot, it was for my own good. The law professor was saying, in effect, look, you want to be a lawyer? You've got to come out of your shell and learn how to think on your feet, learn how to make an argument on your feet, and so forth. So judges will be hard on attorneys in court. The law professors are simply preparing you for that day. So you can't really blame the law professors. They're doing what they believe to be in your best interests. Okay, that's enough for today. It took exactly an hour and 15 minutes. I'm looking at my screen. Now, the second lecture this week, will be put up on Friday, almost certainly, and I'll send an email once it's up. And it will be the first of 3 lectures on Lon Fuller, the case of the Spelunkian explorers. So please, before you watch my video, read at least 1/3 of the case, the hypothetical case, preferably half of it. That way you know you've gotten far enough. And if you can, read all of it. Be prepared when you turn on my video on Friday. Make sure you have the case in front of you, having read it, and have my lecture notes there in front of you as well, so you can follow along. Okay, have a great day. I'll see you sometime Friday on the computer screen.